Namaste everyone, I am Taniya Pandey and I welcome you to today's episode of Courts This Week on LiveLaw. Every week we bring to you updates regarding the most recent judgments and orders being delivered in various courts across India. To stay updated, subscribe to LiveLaw and click the bell icon to not miss any videos from us. Let us cover judgments from the first week of May today. A 3-judge bench of the Supreme Court on 6th May referred to a constitution bench limited questions pertaining to the legal dispute between the Delhi government and the central government regarding the control over administrative services in the national capital. The bench has directed the matter to be listed next on 11th May. The bench of CJI N.V. Ramana and Justices Suryakant and Hima Kohli observed that the main contention relates to interpretation of phrases "any such matter is applicable to union territories" and "subject to provisions of this constitution" in Article 239AA, Clause 3A. In February 2019, a 2-judge bench of the Supreme Court had delivered a split verdict on the question of powers of the Delhi government and union government over services and referred the matter to a larger bench. Last month, a 3-judge bench led by CJI Ramana had decided to take up the case. The Supreme Court has observed that the excess payment of emoluments or allowances to an employee are not recoverable if it was on the basis of a particular interpretation of rule or order which is subsequently found to be erroneous. This relief against the recovery is granted not because of any right of the employees, but in equity, exercising judicial discretion to provide relief to the employees from the hardship that will be caused if the recovery is ordered, the bench of Justices S. Abdul Nazir and Vikram Nath said. The Supreme Court has ruled that there is a difference between the arbitrator appointed under Section 11, subsection 5 and under Section 11, subsection 6 of the Arbitration and Conciliation Act 1996 and failing any written agreement between the parties on the procedure for appointing an arbitrator under Section 11, subsection 2. Application for appointment of arbitrator shall be maintainable under Section 11, subsection 5 and not under Section 11, subsection 6. The bench of Justices M.R. Shah and B.V. Nagaratna held that once the dispute is referred to arbitration and the sole arbitrator is appointed by the parties by mutual consent, the arbitration agreement cannot be invoked for the second time. The Supreme Court on 4th May held the Kerala Revocation of Arbitration Clauses and Reopening of Awards Act 1998 to be unconstitutional, as it had an effect of annulling the awards passed by the arbitrators and the judgments and decrees passed by the courts. A bench of Justices L. Nageshwar Rao and B.R. Gavai dismissed the appeals filed by the state of Kerala. The top court held that the State Act, which has the effect of annulling the awards which have become rules of court, is a transgression on the judicial functions of the state and therefore violative of doctrine of separation of powers. The Supreme Court has held the power of the arbitral tribunal to award interest is subject to an agreement between the parties to the contrary. The court held that the tribunal cannot award interest to the parties if they have agreed otherwise. The bench of Justices L. Nageshwar Rao and B.R. Gavai held that when the parties have an agreement between themselves that governs the issue of interest, the arbitrator would lose its discretion and will be guided by the agreement between the parties. The court held that party autonomy is the cornerstone of the Act and the discretion available with the arbitrator would cease to have effect if the parties have exercised their autonomy under Section 31, 7A of the Act. Let us now go over judgments from the High Courts and other courts. The Kerala High Court on 6th May allowed the appeals moved by state-owned oil marketing companies challenging the interim order issued in favour of Kerala State Road Transport Corporation, KSRTC, wherein the oil marketing companies have been directed to levy the price of high-speed diesel at par with the price available at retail pumps temporarily. A vacation bench of Justice C.S. Dias and Basant Balaji set aside the impugned interim order passed in a petition moved by KSRTC, citing that there was an arbitration clause in the agreement between the parties. It was further held that when a party invokes the plenary power of the High Court to issue a prerogative writ under Article 226 of the Constitution of India, irrespective of the arbitration clause contained in the contract, and the opposite party objects to the maintainability of the writ petition, the High Court is bound to consider the objection and be satisfied that it is a fit case to exercise its discretion instead of relegating the parties to the alternative remedy. The Delhi High Court has reiterated that a convict under the Protection of Children from Sexual Offences Act 2012 is not barred from seeking parole, as discretion has been vested in the competent authority to grant parole to such a convict under special circumstances. Justice Asha Menon added that while there is no doubt true that the legal services authorities at all levels endeavour to provide excellent legal assistance to those in prisons, however, to deny the convict an opportunity to engage with other counsel to enable him to make up his mind freely as to whom he would wish to engage would violate his constitutional rights to legal representation. The High Court of Madhya Pradesh recently set aside the conviction of a man for murder and further directed the state to pay him compensation worth Rs 42 lakhs, observing that his conviction was a result of a botched and maliciously motivated investigation by an outright partisan police. While directing the state to pay compensation, the division bench of Justices Atul Sridharan and Sunita Yadav further held that the appellant was free to proceed against the state for an action in tort for malicious prosecution. The Calcutta High Court on 6th May has recommended that appropriate amendments be made to the Code of Criminal Procedure for incorporating provisions for trial in absentia of an absconding accused for better administration of justice and to prevent the loss of valuable evidence due to death of a witness. It set aside, as per the existing law, a lower court order that allowed deposition of a gang rape victim recorded during the trial of 3 other accused in the same case to be used against 2 absconding accused who were arrested later on. The Jharkhand High Court has held that though the Indian Penal Code does not provide any guidelines as to when a person may be directed to undergo simple imprisonment or rigorous imprisonment, the court, while passing an award, must exercise its discretion judiciously. Justice Sri Chandrasekhar observed that the court should assess the mitigating as well as aggregating circumstances in the case, and upon weighing both types of circumstances, should decide the mode and quantum of punishment to be inflicted upon the convict. While observing that independent MP Navneet Rana and MLA Ravi Rana had crossed that line of freedom of speech in their interviews to the media in the Hanuman Chalisa row, their acts were prima facie not seditious, the special court had said in their bail order. On 4th May, the special court granted the duo conditional bail in the sedition FIR over forcibly wanting to chant the Hanuman Chalisa outside the personal residence of Uddhav Thackeray, Chief Minister of Maharashtra. The judge was of the view that statements made by the Ranas against the CM were extremely objectionable. However, Section 124A of the IPC would apply only when the written and spoken words had the tendency or intention of creating disorder or disturbance of public peace by resort to violence. A Delhi court on 6 May framed charges against former Aam Aadmi Party councillor Tahir Hussain and 5 others in a case relating to the Northeast Delhi riots of 2020. While doing so, it observed that Hussain was not a mute spectator but had taken active part in the riots and instigated the members of the unlawful assembly to teach lessons to persons belonging to the other community. Additional Sessions Judge Virendra Bhatt observed that prima facie there was an agreement between all of them to commit vandalism and arson in the properties belonging to Hindu community from the building belonging to Tahir Hussain, and that elaborate preparations had been done to fulfill the object of the agreement or conspiracy. That's all for today. I appreciate you joining us. To continue staying updated about the latest legal developments, subscribe to LiveLaw and click the bell icon to not miss a single video. I'm Taniya Pandey and you're watching Courts This Week. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.